Losing a loved one is incredibly difficult. Amidst the heavy grief and fond memories, the last thing your family wants to navigate is a complex legal system. That system is called probate. While it might seem overwhelming and confusing at first, it is entirely manageable once you understand the basic steps. We are here to help you understand what to expect. Please note, this video is for educational purposes only and is not a substitute for professional legal advice. When dealing with the loss of a loved one, the term probate is often mentioned, but what exactly does it mean? At its core, probate is the legal process of administering a person's estate after they pass away. It is a court-supervised administration designed to wrap up a person's legal and financial affairs. During this procedure, the court oversees several key tasks. It starts with validating the deceased person's will. Next comes settling the estate, which involves identifying all assets and paying off any outstanding debts and taxes. Finally, it concludes with the official distribution of the remaining assets to the rightful heirs or beneficiaries. When a loved one passes away, you might wonder why the legal system needs to get involved at all. It can feel like an unnecessary hurdle during an already difficult time. However, probate serves several critical functions designed to protect everyone's interests. First, it ensures a will is legally valid. Second, it temporarily secures and protects the deceased's assets. Third, it guarantees that legitimate debts and taxes are paid. Fourth, it provides the clear, legal transfer of property titles to the rightful heirs. Finally, it offers a neutral, structured environment to resolve any disputes among family members or creditors. Ultimately, it is a system built to ensure absolute fairness and transparency. One of the most confusing parts of the probate process is figuring out what goes through it. Not everything a person owns is a probate asset. Let us break it down into two categories. Probate assets are items owned solely by the deceased person, without automatic instructions on who gets them next. This includes individual bank accounts, real estate deeds solely in their name, or a car title with one registered owner. Because there is no joint owner, the court must step in to legally transfer ownership. Non-probate assets bypass the court system and pass directly to new owners. Examples include joint bank accounts, real estate held in joint tenancy, life insurance policies, and 401k retirement accounts with designated beneficiaries. Assets properly placed inside a living trust also skip probate, saving the grieving family time and legal fees. While probate might seem overwhelming, it generally follows 8 standard steps. The journey begins by filing a petition with the local probate court to open the estate. Alongside this, if the deceased left a will, the court must validate it, ensuring it meets all legal requirements and is genuinely the final testament of the deceased. Once the will is validated, the court appoints a personal representative or executor to manage the estate. This person is granted the legal authority to act on behalf of the deceased. Their first major duty is sending formal notices to all legal heirs and known creditors, giving them an opportunity to step forward with any claims. Next comes the inventory and appraisal. The executor must locate, identify, and value all estate assets, from real estate to antique furniture. With a clear picture of the estate's total value, the executor then pays off any legitimate debts and final taxes. This is a critical phase, as creditors must be paid before anyone inherits. After debts and taxes are settled, the remaining assets are finally distributed to the rightful beneficiaries, according to the will or state law. Once everything is transferred, the executor submits a final accounting to the court. The judge reviews the records, discharges the executor, and officially closes the estate, bringing the probate process to an end. At the center of probate is the personal representative, often called an executor. Acting as a fiduciary, they are legally bound to manage the estate with the highest good faith and integrity. Their duties are vast. They must locate and protect assets, pay outstanding debts and taxes, and keep meticulous records. Compassionate communication with grieving family members is equally vital during this difficult time. Once all legal obligations are settled, the representative distributes the remaining assets to the rightful heirs, completing the probate process. How long does probate actually take? A simple estate might pass through the system in a few short months, but larger, more complex estates can easily take a year or more. The timeline is heavily influenced by the size of the estate, the types of assets involved, and the current backlog at your local probate court.
Another major factor that can drag out the process is family disputes. If heirs contest the will, the timeline extends significantly, keeping the estate tied up in stressful legal proceedings.
Then there is the financial toll. Between attorney fees, court filing fees, personal representative compensation, appraisal fees, and bonding fees, the expenses add up quickly. Typically, you can expect the probate process to consume anywhere from 3% to 7% of the estate's gross value, significantly reducing the final inheritance. Navigating probate can be daunting, but there are smart strategies to bypass it. The most effective tool is a living trust. By transferring assets into a trust during your lifetime, they pass directly to beneficiaries, entirely avoiding the probate court. Another simple method is joint ownership with rights of survivorship, automatically transferring property to the surviving owner. You can also use payable on death designations for bank accounts and transfer on death registrations for brokerages to ensure funds transfer instantly. Finally, smaller estates often qualify for simplified procedures. For example, in California, estates valued at $184,500 or less can use a streamlined process, saving families both time and money. What happens if your loved one passes away without a will? In legal terms, this is called dying intestate. When this occurs, you don't get to decide who inherits your assets. Instead, state laws step in to dictate the distribution. These intestacy laws vary heavily depending on where you live. The probate court will appoint an administrator to manage the estate. Assets then flow down a strict legal hierarchy, usually passing to a surviving spouse, children, or parents. Navigating probate during a time of loss can feel overwhelming, but you do not have to do it alone. Seeking professional legal guidance is one of the most important steps you can take to protect your family assets and ensure the process goes smoothly. To find the right help, visit probateus.com. Our platform makes it easy to connect with qualified probate attorneys in your area and locate your local probate courts with just a few clicks. Thank you so much for joining us today. We know that navigating the loss of a loved one is difficult, and we hope this guide has helped clarify what probate is, why it is necessary, the steps involved, and how you can proactively plan ahead. If you found this video helpful, please give it a thumbs up, subscribe to our channel, and leave any questions or experiences you might have in the comment section below. We are here to support you. For more detailed resources, helpful checklists, and step-by-step guidance, please visit probateus.com. Take care of yourself and your family, and we will see you in the next video.